Hi, my name's Gary Goyer, and I'm the lead wage and hour attorney at Goyer & Associates. The question is, does an employer have to pay overtime to an employee when they don't know the employee has done the work? And it's a very interesting question under the law. The obligation and the burden is on the employer to pay for the time if they knew that it happened or should have known that it happened. So it's not just a matter of when an employer orders an employee in writing or even verbally, hey, go do this extra stuff above your 8-hour day that's going to cause overtime. Instead, is there work occurring that the employer knows about or should have known about? And what does should have known about mean? Well, an employer has the ability to know how much work is getting done, what reports, what work product is getting done, depending on the type of work. If they know that an employee is cranking out that work and getting it done, and there's no way it could happen in an 8-hour day, they're going to be responsible for overtime for that extra time. If instead the employee is secretly doing work without the employer's knowledge and there's no way the employer could have known about that, that's not going to be held to be compensable time. I could talk for hours about the difference between federal wage law under the Fair Labor Standards Act, or the FLSA, and California wage law. Some elements are the same, some are very different. California is typically more protective for the employee and creates a higher burden for the employer. The federal law under the FLSA is a little more flexible, and there's differences between the two. But overall, the employer should use the rule if they know the work's going on, or should know, if they're benefiting from that work and the employee is prevented from going about their own way before or after the work shift, that's going to be compensable time for which overtime pay is going to have to be provided. Well, of course, the traditional way for an employer to pay overtime is by cash or cash equivalent, and it's usually not cash. It is a manual check or maybe electronic deposit, typically done on a regular payday. Paydays are usually every 2 weeks or twice a month, and as long as it's under a policy established by the employer that the employee knows about, that's what's accepted. There is some exception where compensatory time off, or CTO, can be provided in lieu of overtime, in lieu of cash overtime pay. But that has to be agreed to between the employer and the employee prior to the time they incur the work and have the overtime hours. That agreement can happen through a collective bargaining agreement or an individual agreement, but it has to be agreed to first. So there can be CTO, but typically it's cash or cash equivalent provided by the employer. The question is, why pay the overtime? Well, because it's the law. That's the short answer. And if you don't follow the law, there may be consequences to that. Not just later having to provide that amount of overtime pay to the employee, but interest and penalties. In fact, in California, there's something called waiting time penalties, which means on the day an employee's employment ends with an employer, they have to be provided everything they're owed. Straight time pay, overtime pay, accrued vacation, any other benefits that have monetary value. And if they're not, that employee can come back later and get what's called a waiting time penalty, which is their daily rate of pay up to 30 days worth of that if the employer didn't provide them with everything. So you got to follow the law, or you're going to have some consequences that mean you're going to pay above and beyond the actual overtime pay amount that was owed. For more information, you can click on the link and fill out the contact form below. Once we get the additional information, we'll get right back to you if you're an employer, to help you solve the problem you may have. If you're the employee, to let you know whether or not you have a claim that can be pursued. Thank you.